Okay, well, people will, I think, continue to log on, but I think now's a good time to start. Welcome everybody. It really is wonderful to have so many of you able to join us today. I'm Peter Danchin, Associate Dean for Research and Faculty, and we really have a terrific program for today's faculty webinar, the next in our continuing series this year. The topic for today's webinar is a new era, ? The current state of immigration law and policy. And I'm going to hand over directly to my colleague, Professor Leigh Goodmark, who's the co-director of our clinical law program, who's going to be introducing our wonderful speakers and moderating today's discussion. So over to you, Leigh.
Thank you so much, Dean Danchin. It's a pleasure to be here with all of you today. Undocumented immigrants and those who fight for them have faced unprecedented challenges in the last several years. And in Maryland, the Maryland Carey Immigration Clinic has been at the forefront of those efforts to protect undocumented people. The Immigration Clinic has long been a mainstay of our clinical law program, and their efforts received a significant boost recently with the incredibly generous gift from Dr. Marco and Debbie Chacón. Today, we're going to talk about the Chacón Center for Immigrant Justice and the vital work that that center will do on behalf of immigrants in Maryland and throughout the nation. In just a moment, I'll introduce our panelists, but just a couple of things about the chat. Throughout the presentation, I'll be posting links in the chat for those of you who are interested in following up on some of the things that our panelists talk about. Also, if you have questions, please feel free to post them in the chat, and I'm happy to ask them of our panelists. So to introduce our panelists today, first, we have Professor Maureen Sweeney, who will be the director of the Chacón Center for Immigrant Justice and has been the director of the Immigration Clinic since 2004. Prior to joining the Maryland Carey Law faculty, Professor Sweeney worked as a lawyer representing immigrants and migrant farm workers in employment-related cases and in immigration matters. Gabriela Kahrl is a staff attorney with the Immigration Clinic and has been since 2017. Before that, she was an assistant public defender for 6 years, focused on representing non-citizen clients facing deportation as a result of involvement in the criminal legal system. Gabriela is also a graduate of Maryland Carey Law. Lucy Martin is a fourth-year evening student. This is her second year in the Immigration Clinic, and she is doing law school while having and raising a now 3-year-old daughter. Ms. Martin is currently interning with Kind Kids in Need of Defense in Baltimore and has volunteered on the border with families seeking asylum. And last but absolutely not least, Dr. Marco Chacón is here on behalf of himself and his wife, Debbie. Marco and Debbie Chacón have supported entrepreneurial, philanthropic, and educational initiatives at the University of Maryland, Baltimore for a number of years. Their company, Paragon Bioservices, Inc., was a leader in the field of viral vector development and manufacturing for gene therapies and was the cornerstone of the UMB Biopark in its early years. Dr. Chacón, a native of Costa Rica, is also the founder and CEO of Irasu Bio, a drug development company headquartered in the Biopark. In addition to providing the gift that is launching the law school's Chacón Center for Immigrant Justice, the Chacóns founded the Alicia Inyaya Foundation, which supports work on behalf of science, education, children, and the less fortunate. Thank you all for being here today. And I'm going to start with you, Professor Sweeney. We are all very excited about the Chacón Center for Immigrant Justice. Can you give us a sense of your vision for the center?
Sure, very gladly. The center will be a place where we value, honor, and serve people who come to the United States to find either a safe haven or a better future for their families. Our values include the fact that we recognize that none of us is perfect, but that we all deserve the chance to live a full and dignified life. And the belief that we as a nation need a legal system that is free of structural racism and that guarantees basic human rights. These are values that we don't necessarily currently see reflected in our immigration system, but that's what we work for. The center will include our current immigration clinic, which will continue to represent individuals and families who are seeking asylum and also defending themselves from deportation because of criminal convictions and other contacts with the criminal justice system. In the clinic, we don't shy away from the hard cases, again, because we recognize the potential for human redemption and forgiveness, and we also recognize the unequal price that's paid in our criminal legal system by people of color. The center will expand our clinical offerings by allowing us to create a brand new federal appellate clinic that we're extremely excited about. This will allow our students to work on federal appeal work in the Federal Court of Appeals, the Fourth Circuit, and will also provide crucial representation in cases that can set legal precedent for the entire region, the 5-state region that's covered by the Fourth Circuit. So in these 2 clinics, we will continue to train lawyers to represent immigrants at the highest levels of excellence in terms of legal work in court, but also advocacy in legislative work. The center will allow us to continue the work that we do in Annapolis to advocate for policies and laws in the state of Maryland, and will also allow us to integrate more of the immigrant community through our citizenship initiative, which will help people attain citizenship, but then also exercise their full rights as citizens in the advocacy community. And then finally, the center will allow us to expand work that we do training lawyers and representing people to challenge old convictions that are resulting in unreasonably severe immigration consequences. There's a lot more detail on the website, so I encourage people to look for the Chacón Center on the law school's website.
Thank you, Professor Sweeney. So Dr. Chacón, I want to turn to you now, and again, to tell you how grateful we are for this amazingly generous gift that is going to do so much for the students at our law school. And I'm curious if you might share with the folks who are with us today, what is it that made you want to focus on immigration?
Well, becoming aware of the double standard of justice that seems to be affecting the immigrant community. So it became clear to Deb and myself that people deserve, a level of representation in this country to hopefully keep them away from lengthy incarcerations, even without trials, deportations that are way too readily implemented that clearly destroys entire families. And last but not least, we certainly became enraged, to be quite honest with you, at the inhumane and horrible practice done up until recently of separating immigrant families, the children from their parents and so on. But it seems, goes beyond that as well, because if you notice, it goes beyond, our southern border, but it also, there's plenty of hatred and plenty of intolerance in our society, currently affecting quite directly the Asian American immigrant communities. So to the degree that we can affect sort of the curve to some degree by aligning ourselves with a passionate group of people of vision, people of conscience, as you folks from the School of Law, it became clear that this was something that Deb and I would be very much delighted to support.
Thank you so much, Dr. Chacón. So, Professor Sweeney, all 3 branches of government touch on immigration policy. What do you think are the most pressing immigration issues currently facing the United States? Professor Sweeney, you need to unmute.
Oh, of course I do. Yeah, I think we'll start. We're gonna talk about kind of some of the action in each of the branches, but I want to start with the executive branch because I think the most urgent priority for the executive branch currently is the large number of people coming to the border. If you've been looking at the news, you've certainly heard about that. Both as a humanitarian issue and as a political issue, frankly, this is something that the Biden administration is having to deal with immediately. I want to give a little bit of context for it, though, because it's not a new phenomenon. Of course, we've had large numbers of especially Central Americans, but also people from other countries coming to the border for years now, as a reflection not of US immigration policy, but of conditions in their own countries. And conditions have worsened in Central America, where many of these folks are coming from. We've had a series of natural disasters recently, which are worsened by climate change, so we can't really expect those to stop coming, as well as an increase in violence and impunity for gangs and police corruption that has led to a breakdown of civic life in some of these countries that is causing people to have to flee. COVID has ruined much of what's left of the economies in these countries as well. So conditions are particularly dire, and for people to take on that trip over land to the US border with the uncertainty of what will happen to them when they come here is a testament to how untenable their situations are in their home countries. So that's a lot of what's behind the current numbers. The other thing we have to recognize is that there's a backlog from the last 4 years of people entering the US, people who have either held off coming to the border because of the inhumane conditions, or people who were expelled and kept in the Remain in Mexico program, so that those people are now being admitted by the administration. And that's part of what's happening in terms of people crossing the border. But the reality is that the administration at this point is not prioritizing asylum protection and is not responding to the sort of broader questions of displacement, but is in fact expelling most people at the border under the Trump era public health order that under the guise of COVID is simply rejecting people without any interview, any consideration of whether they might be entitled to apply for asylum. So you hear a lot about how everybody's just pouring in, but that in fact is not the case. So I think that is something that the administration is obviously scrambling to respond to. That being said, the executive branch, which is are the enforcement agencies, as well as the other aspects of the Department of Homeland Security, are also taking steps to make some amends for the damage that was done, frankly, by the previous administration. And that is, and one example of that is the task force that is working to reunite the families that were separated that Dr. Chacón referred to a few minutes ago. So those are a couple of the priorities that I see.
And how do you see the center being involved in the work on those issues that you've just named?
So we see people once they have come in to the US. So a lot of the families that are at the border right now will eventually apply for asylum. And so that's the bulk of the work that we're doing in terms of representing people in immigration court, is representing those families. The other thing that I didn't mention about the center is that it also provides funding for students to go on alternative spring break trips. And we hope soon to be able to resume those trips. And we were all set last year to take a group to the border to work with an organization and to work with the families there at the border, but had to cancel it because of the pandemic. But that is a potential alternative spring break for next year or the future.
So Ms. Martin, I want to turn to you now. I know that you've been working with KIND, Kids in Need of Defense, assisting families at the border. Can you talk a little bit about the work that you've done there? Help the folks who are watching kind of understand in a more visceral way what that actually feels like to be a family at the border.
Hi, yes, thank you so much for having me. What it actually feels like to be a family at the border. Well, so this semester, I'm an intern at Kids in Need of Defense, or KIND, on their family separation team. And KIND has a US-based team and an international team working on family separation issues. So personally, I'm not working with people that are at the border right now, but I am definitely exposed to a lot of the situation that people were in during zero tolerance under the Trump administration. So that's what I'm working on right now. Primarily, I've been working with the US-based team assisting with direct representation of children who were separated from their parents under zero tolerance. I'm preparing state court filings for children who are eligible for special immigrant juvenile status, which is something I hope to build a career on, but I'm also lucky enough to be involved with a special project making phone calls to deported parents in 2017 and 18, most of whom have not seen those children since. So to give a brief, broad background, prior to Operation Streamline in 2005, which was initiated under George W. Bush, but vastly expanded under the Obama administration, first-time illegal entry without aggravating circumstances was rarely even prosecuted at all. It's now the most prosecuted federal crime in the United States. Even so, there was a longstanding policy of not prosecuting adults who would have to be separated from their children to do so. The zero tolerance policy of 2018 changed that, and that's when family separation exploded into the news to massive public outcry. In 2018, the ACLU brought a lawsuit, Ms. L versus ICE, and a federal judge ordered the US government to end zero tolerance and reunify the over 2,700 families forcibly separated under that program, which was later expanded to include over 1,500 additional families separated under a secret pilot program in 2017. However, roughly 1,000 families have been separated since the end of zero tolerance, due to an section in the ruling allowing child separation from an unfit parent. There may be many cases of actual unfit parents, but I've heard a story of a mother being found unfit because she had a broken leg. The judge in Miss L also ordered the creation of a steering committee to locate all separated families using contact information the government was ordered to turn over. The steering committee is led by the law firm Paul Weiss and includes 3 nonprofits, the Women's Refugee Commission, Justice in Motion, and KIND, where I am. These groups made phone calls and even went to Central America to track down these families, including hundreds of parents who were deported without their children. Around 500 families have yet to be tracked down at all. Previously, when people were contacting deported parents, the only quote unquote options available to them were to have their child return to their country of origin or to remain separated. Many parents felt that their children were not safe in their country of origin, which they had fled. In this way, the government claimed that parents had the opportunity to reunify and were choosing to remain separated. But of course, it was not much of a choice at all. Recently, the Biden administration announced a family who hopefully at some point will come up with some kind of plan for these families. Secretary Mayorkas signaled that the administration may offer an option for reunification in the United States. So I have the lucky job of being able to call these parents with some actual hope, although we don't know what the government will offer them or when. The idea is to confirm that the parent would like to reunify with their child in the United States and get their permission to find them a pro bono attorney to represent them so that we will be ready when the relief is announced. Applying for humanitarian parole into the US for deported separated parents, even before the announcement of relief, is also an option and has had some small scale success for clients of KIND and another nonprofit on the border, Al Otro Lado. There have been many challenges, even in my small role in supporting this project. Deported separated parents, unsurprisingly, show deep distrust of the US government, and I feel they have deep distrust of me. People may have changed phone numbers by now. It's been several years since the number the government gave the steering committee was up to date. Some deported parents are on the run from the persecutors they fled when they came to the United States. Some have experienced very serious persecution since being forcibly returned. Some have had their homes wiped off the map by the recent hurricanes in Central America. A lot of these families are experiencing threats from criminal groups by phone, and I'm calling and saying, hey, I've never met you. Can you tell me where your child lives and how to get in touch with them? I called one father who told me he speaks to his 2 sons regularly, but has no idea where they live or what their phone numbers are and is unable to find out. My guess is that he understandably does not share this information at the drop of a hat. As a child welfare organization, we also call the child who was separated from that parent to confirm that they're on board. Unlike the deported parents who have already been located and contacted by the steering committee, I am the first person to reach out to the child about possible reunification. Speaking to the children presents challenges. If there's a young child, I speak to their sponsor, usually an aunt or uncle or grandparent they're living with in the US. But if the child is over around 13, I really try to speak to the child. So far, none of them have really wanted to talk to me at first. I've had to reach out by text, I failed phone call attempts and been told I do not answer unknown numbers. It's also a very heavy question to ask a child. Do you want to see your parent again? If only it were possible, it feels like the kind of question a social worker or therapist should be asking over a long trauma-informed relationship. But this is not possible, and these families have been waiting far too long already. Generally, the answer from both parties has been a resounding, of course, thank you, God bless you. I'm very honored to be supporting the steering committee. As the mother of a 4-year-old daughter who has special needs and whose father is from Honduras and who was a baby when this started going on en masse, I don't think there's any single issue that I feel quite as deeply as the fact that my government deliberately ripped asylum-seeking children, including breastfeeding babies, from their parents' arms. It is my sincere hope that either the task force or the eventual resolution of Ms. L versus ICE and other lawsuits will result in the reunification in the United States, permanent protection, financial restitution, and ongoing psychological support for the families we serve. The school's immigration clinic has prepared me for this work in so many ways. My clinic experience is probably why Kind took me as an intern in the first place. I've had the opportunity to develop knowledge of the current state of affairs, the context, the players involved, and possible forms of relief for those affected. I've also developed skills in terms of speaking to clients in general, speaking in Spanish in a professional setting, and building trust with clients, even when it's only over the phone. I can never express how much my confidence as an advocate has been enhanced by my experience in the clinic. So thank you to the Immigration Clinic, thank you, Carey Law community, and thank you for listening to me today.
Thank you so much, Ms. Martin. So Professor Kahrl, I want to turn to you next. We've heard about a lot of problems, and I think there are probably additional problems we've not even talked about yet. Are there legislative fixes that are currently being considered for any of the problems that we're seeing in the immigration context?
Yes, but don't hold your breath. But before I get into the legislative update, I just wanted to say that the work that the clinic students do, and I guess that Professor Sweeney and I do, is difficult, but the students really come at this fresh, enthusiastic, and they are just pummeled by the pain of our clients and of the stories, and they just do remarkably well with it, and are such powerful advocates. And I really just want to lift up what Lucy just shared with us, because it was so powerful, and I know it wasn't easy to talk about. So thank you, Lucy, you're amazing. And also just that I think a lot of the immigration conversation, this is something that Marco has brought up too, has created kind of a lopsided vision of immigrants in the United States. We get a lot of very important information about all the horrible things that immigrants have to go through to try to come to the United States, but that's one important bit of information, but we don't hear about all the wonderful things that immigrants are doing right now in the United States, have done and will continue to do, and how they contribute to making this country what it is and moving it forward to a better and better and more equal vision. So I know that a lot of what Maureen and I want to do with the citizenship initiative is to make sure that we kind of put out there all the other immigrant stories that there are that are really very important and good and true. And so with that, I will now turn to the legislative update. And like I said, don't hold your breath. Immigration reform is in the hands of Congress. Any permanent workable immigration reform will have to be legislative. Currently, there are over 50 immigration bills pending in the 117th Congress, but I'll just focus on 3 of them. There are 2 DREAM Act bills. If that name sounds familiar, it should. This kind of legislation has been introduced before, but it's never passed. The 2 current DREAM Act bills are the DREAM Act of 2010. That's a bill that originated in the Senate. It's bipartisan, and it is currently just sitting in the Senate. It's been referred to the Committee on the Judiciary. Not much has happened with that. The next one has passed the House. It's the American Dream and Promise Act of 2021. President Biden supports this bill, and he issued a press statement to that effect. And like I said, it has passed the House. Both create a path to citizenship through a 3-step process. I'm not going to spell out the process for you. I'll just give you a broad overview. The initial requirements are that the person come to the United States as a child and either is pursuing or has a high school diploma or equivalent. To access the additional benefits under the bill, a person must continue to make steady progress at college or other institutes of higher learning, or complete military service, or demonstrate steady, authorized legal employment over a period of years. Assuming one meets these requirements, the final stage is a standard naturalization process to obtain citizenship. The differences between the two dream bills, well, the main difference is that the American Dream and Promise Act is a little bit more expansive than the DREAM Act. It also makes holders of TPS, that's temporary protected status, and deferred and forced departure eligible for the bill's benefits. It allows eligible Dreamers who have been deported under the Trump administration to apply for relief from outside of the country. It repeals 1996 laws that penalize states who grant in-state tuition to undocumented students. And it allows Dreamers to access federal financial aid. The third bill I wanted to talk to you guys about is the Farm Workforce Modernization Act of 2021. This is a bill that would address the growing labor crisis in the United States by ensuring that U.S. farmers have access to the workers they need to perform migrant labor work that U.S. workers are generally unwilling to do. Right now, farmers lack workers to do this agricultural work. And if it continues, farms will shut down and the United States will become more dependent on imported food, will increase trade deficit and dangerous dependence on foreign countries for health and safety of our food supply. The FWMA, that's the bill, establishes a program for agricultural workers to earn legal status through continued agricultural employment. The bill also reforms the H-2A temporary agricultural worker program, so there's more flexibility for employers and ensures critical protection for workers. This bill does have bipartisan support, and it passed the House with 30 in favor from Republicans.
Thanks, Professor Kahrl. So what work can the center do in terms of federal legislation and also state legislation? Is there any interesting state legislation that we should keep our eyes on that you might be working on?
Yes, so we primarily do work in the Maryland General Assembly, and there were several immigration bills that were introduced in the 2020 legislative session. And we were a little concerned initially that people would feel, or the Maryland state legislators would feel, that they could kind of rely on the Biden administration to solve all of the problems. But the truth is that there are many problems that cannot be solved by the federal government, or will take a long time to be solved by the federal government, that really Maryland legislators have the ability and the responsibility to address. And so some of the legislation that was introduced this session that the clinic worked on or supported was the Trust Act. That's a bill to prevent state and local law enforcement from working with ICE. A bill called Dignity Not Detention that prevents ICE detention contracts in Maryland and attempts to limit the building of any facilities that would house people who are detained by ICE. A right to counsel and immigration proceedings bill. That's a bill that would provide lawyers to indigent immigrants who are facing deportation and who are detained in Maryland and are also Maryland residents. And a bill, a probation before judgment bill, and that's kind of a criminal justice reform bill and immigration bill that basically ensures that all people have access to probation. Right now, the way that probation is structured in Maryland, it can lead to deportation for non-citizens. And the clinic has done a lot of work in support of a lot of these different bills. We've lobbied for the bills with legislators and stakeholders. They have testified, our students have testified in the House and Senate on multiple bills, as have Professor Sweeney and I. We've also done all kinds of creative things. You know, in this COVID times, we're not obviously able to meet with people in person, so we have created videos to kind of illustrate a lot of the important issues and points that the bills that we were supporting would address. And also our students drafted an op-ed that was published in the Baltimore Sun in support of a bill. The bills that have the best chance of passing right now is the Dignity Not Detention Act. It got through the House, it's in the Senate right now, and they're going to try to fold the language of the Trust Act into the Dignity Not Detention Act because the Trust Act has kind of stalled in the Senate right now. The Driver Privacy Act is also in good shape. It passed the House, and it looks like it's going to be voted on in the Senate either today or tomorrow. And then there's a bill a small immigration bill, the Immigrant Affairs Office and the Governor's Office. It looks to have passed both houses, and actually Professor Sweeney gave really important testimony in that bill. And that's like kind of a small immigration bill, but it's important because it will help to protect immigrants who have to deal with fraud and really have no one to go with their claims of fraud, where people basically take advantage of the instability of their position to exploit them or extort them for money by claiming to be from ICE and threatening all kinds of things that they, of course, believe because they're so afraid.
Thank you, Professor Kahrl. a list of all of the bills. So Professor Kahrl or Professor Sweeney, is there a place where people can find a list of all the bills? And note that we've been putting links to at least the federal legislation in the chat, but is there a place to get a list of all of the Maryland bills?
You can go to the Maryland General Assembly website to look up a lot of the bills, but I would also just go, you could also just go to CASA's website, CASA de Maryland. They have 4 of the immigration bills, and some of the ones that I've mentioned were priority bills for CASA, and they will have extensive information about them. Yeah. And if you email me, I think I'd be happy to provide you with any information on the bills too.
Thank you, Professor Kahrl. And Professor Weiss notes that the Maryland General Assembly is also considering several bills about food and farm worker health and safety, as well as other general legislation, noting that the food and farm worker population is 50% undocumented, 40% H-2A immigrant.
Thank you so much, Professor Weiss. No, Professor Weiss taught me torts.
All right. I want to remind people too, you're starting to take advantage of the chat. Please, if you have additional questions, post them in the chat as we're talking and we'll fold them into our conversation. But Professor Sweeney, I'm going to turn back to you now. So we've talked about executive action and we've talked about legislative action, and that leaves us with one branch left, and that's the courts. And there's been considerable turnover in the federal courts over the last several years that may have really profound implications for undocumented people. I wondered if there's anything you'd want to talk about in that context.
Sure. The change in the courts is going to have a profound effect on immigration, the interpretation of immigration law for a long time to come. The courts were something of a bulwark in the Trump administration against a lot of moves that the administration tried to make that were contrary to either the Constitution or in most cases to the Immigration and Nationality Act. And so the courts were a really key player and will continue to be a key player. But as you say, there has been a lot of shift, a lot of turnover in the courts. They have taken a more conservative and a less positive turn, I guess, for immigrants. I'm going to give an example of a case that the Supreme Court just decided on March 4th called Pareda versus Wilkinson, which was a case, it's a kind of a technical argument in some ways, but the basic legal issue was about what criminal convictions will trigger immigration consequences and which won't. And the Supreme Court has a long line of cases that say that this analysis should be a categorical analysis, so that a kind of a legal determination based on the elements of the offense, so that people who are convicted of the same offense suffer the same consequences, and so that it doesn't rely on the facts of the person's situation, but that there is a fair, similar consequence for a similar conviction. It gets complicated because sometimes a statute has several subparts that are really different crimes, and so the analysis has to take that into account. And the basic problem is that there often are instances where there's not enough information in the file to know which specific subpart of the statute somebody was convicted of. And for 10 years, the Supreme Court has issued a long line of cases basically saying that where there is this kind of uncertainty about exactly what the person was convicted of, the benefit of the doubt should go to the immigrant. And I'm simplifying things a little bit, but that's the basic gist of it. And the reasons that the court gave for this preference, this slight benefit of the doubt that would go to the immigrant, have to do with the power of the state, the power of prosecution, criminal prosecution, the fact that over 95% of criminal cases are resolved with a plea deal that leaves a very sparse record. So it's often hard to tell what exactly happened in the case. There's also there's inconsistent and really, in many cases, lousy record keeping by local criminal jurisdictions, and file destruction policies that, especially in more minor offenses, the files, if they're misdemeanors, the files may be destroyed after 3 years. And so then an immigrant who's coming back later trying to apply for some kind of relief from deportation or naturalization, for example, may not have a record. There may be no record there. And then finally, the court has recognized that immigrants in deportation proceedings are not guaranteed a lawyer. And often, especially if they're detained, will have very little capacity to go find old criminal records. So there's this long line of cases from the Supreme Court supporting this analysis. Most of these cases, at least the recent ones, were written by Justice Kagan. And then we get this there's another case that looks at this same kind of analysis in a slightly different context where somebody's applying for relief. And everything has changed because of the shift in the Supreme Court. So Justice Kagan is now in the minority. She was part of the dissent that was written by Justice Breyer and joined by Justice Sotomayor. Justice Gorsuch wrote for the majority and held essentially in pretty much these terms with not a whole lot more nuance to it, that where there is doubt, there's no reason that the benefit should go to the immigrant, that it should in fact go to the Department of Homeland Security. And there are a couple of things that are, I mean, the shift in the line of case law is remarkable. But even more disturbing than that, there's a kind of a flippancy, a flippant tone to Justice Gorsuch's decision that I find bodes ill for immigrants. And a kind of a willingness to say, well, Congress can do whatever it wants when it comes to immigrants. Many of the protections that come in this line of cases where we're really talking about the overlap of the criminal prosecution process and the immigration enforcement process. Many of the protections for criminal defendants were integrated into this line of cases. But Justice Gorsuch made it very clear that he does not believe that those kinds of protections are appropriate for immigrants, and that if Congress says that the benefit should go to the government, then the benefit should go to the government. There's a question about whether Congress really said that in this case, but at any rate, that was what the court found. And raising again the specter of what we in the immigration world call the plenary power doctrine, which basically says that that Congress can do what it wants with very little judicial or constitutional oversight when it comes to immigrants, which is obviously concerning. So yes, there has definitely been a shift. We see it at the highest levels of the judiciary, and we're going to be working with that as we go forward. With regard to what that means for us and what that can mean for the center, there's a few things where the center is poised to really respond in this arena. As regards this particular decision and the consequences of criminal convictions, the work that we will be doing and expanding, challenging old convictions in Maryland and training lawyers to challenge those convictions through post-conviction or quorum nobis work has become even more important because of this decision. One of the few options that may be left to people is to go back and actually challenge or clarify the record in the earlier criminal proceeding. And so that is really become even more important. And then, of course, the new federal appellate clinic is going to be right in this work of trying to frame up and make sure that cases are presented in the strongest possible way in the courts of appeals, so that they will be set up, if need be, to go to the Supreme Court as well. So we're extremely excited about that new clinic. We'll be hiring next fall to begin the new clinic in the following fall. So it'll be the fall of 2022, I guess, when the new clinic will begin. And we look forward to lots of interesting cases for students to work on in the asylum area, but also in this area that has to do with the consequences of convictions.
So taking moderator's privilege, you know, there's overlap oftentimes between many of our clinics. And so as Professor Sweeney and Professor Kahrl know, the clinic that I direct, the Gender Violence Clinic, has done immigration work in the past as well in the area of T visas and U visas and VAWA self-petitions, which are all remedies that are available to victims of various forms of crimes, including gender-based violence. And I'm wondering, Professor Sweeney, there were some real changes that happened in the last administration around, for example, relief for victims of domestic violence through the immigration system, through the asylum system. What's your sense of what's likely to happen going forward there? And are there other issues kind of percolating from the lower courts that you think we should be keeping an eye on?
There is a whole range of issues having to do with asylum protections that I expect to see a lot of movement on, because the last administration did everything it could to eliminate asylum protection for most, just about anybody. But people who were targeted because, certainly in the domestic violence context, people who were targeted because they were members of particular families. So often one family member would be targeted to pressure another family member to do something, to pay extortion or to support the government or something like that. And the past administration very aggressively used its power. One of the difficulties of practicing in the immigration courts is that they're not independent courts. Okay, the immigration courts reside in the Department of Justice, which is of course an executive branch agency. So the Attorney General, who is a political appointee, has the power to set precedent for the entire immigration court system. And that's what happened in the last administration with regard to a number of issues in asylum. So for example, there was the matter of AB, which was the famous case that tried to eliminate protection for survivors of domestic violence. And that is something that I expect it's under review under the Biden administration. And I expect them to come out with some kind of new case law on that, frankly. On that issue, there'd be the other issue having to do with people who are targeted for family reasons. I expect the administration to deal with that as well. In the meantime, courts continue to process these cases. And we just went to court in the clinic last week on a domestic violence-based case. And the judge didn't issue a decision immediately. I think he may be waiting to see what the administration is going to do with that. So there is some hope that the new administration will take advantage of their power in this area to correct some of what the old administration did. But I see in the chat that retired immigration judge Lisa Dornell is speaking up for independent immigration courts. That's what really has to happen. And that has to be a legislative fix. Congress needs to establish independent immigration courts so that the courts are not subject to the political whims of whatever administration happens to be in power.
And do you think that could be part of a comprehensive immigration reform?
It could be. It is not, as I understand it, part of the large comprehensive proposal that President Biden has proposed, which I was very disappointed to see. But it certainly should be part of a revamping of the immigration system generally.
So again, I want to remind people to please use the chat if you have questions. And Professor Kahrl, I want to turn to you for just a moment, because I know that in your time as a public defender, a lot of the work that you were doing was around challenging and clarifying records to prevent folks who had been criminalized from being unjustly deported. So how do you do that? How do you challenge or clarify a record so that you can prevent deportation?
So we're lucky in Maryland, and all my work was in Maryland. We're lucky in Maryland that we have a robust post-conviction statute, and it basically entitles anyone who has a criminal conviction to raise ineffective assistance of counsel claims against their attorney. Even if the case doesn't have merit, they're actually entitled to a lawyer and to their day in court on that issue. On my cases, when I was at the public defender's office, were all immigrants who had a conviction that made them deportable. And a lot of times they were mostly guilty pleas. And a lot of times, most of the time, they were on extremely minor issues. And they kind of accepted a plea because they were told by their public defender, by their lawyer, many times private attorneys, not just public defenders, just to be clear, that if they took this plea, they wouldn't have any jail time and it wouldn't affect their immigration status. And then in March 2010, a case came out, Padilla v. Kentucky, a Supreme Court case that held that, basically held that criminal defense attorneys had to provide accurate advice to any non-citizen client they had on the consequences of a criminal conviction in the case. And so this was the issue that I was primarily litigating on. If I had a client who hadn't received accurate immigration advice about the consequences of a plea, then we would file a petition, either a post-conviction petition in the circuit court, the relevant circuit court in Maryland, state court, not federal court, or a quorum nobis petition, and we would raise that there was a constitutional violation of their Sixth Amendment right, which was what the Padilla v. Kentucky case relied upon, that they had received inaccurate advice concerning the immigration consequences of this plea that they accepted. And many times with these cases, Professor Goodmark, we didn't even have a trial, because once the state was made aware that what they considered to be an innocuous, unimportant, trivial crime was causing consequences that were sort of not part of any kind of agreement that they had ever contemplated, they wanted to resolve it and work it out. And so we were able to replead the person to something else. Oftentimes, again, there had been no sentence, so there was really no need for any jail time or any issue where someone had already completed their sentence. So a lot of those cases were really just about bringing this injustice to the state's attorney or to the judge, and rectifying a unintended consequence that no one really wanted or had contemplated when the plea was entered.
So we have a question from Professor Grayberg, and I think probably Professor Sweeney for you. What strategies do you use when arguing before conservative justices inclined to support government power in immigration matters?
Well, that's the $64,000 question, really. Often what we are arguing is the statute, right? So we have the Immigration and Nationality Act is the congressional statute, the federal statute that controls most of immigration law, that provides most of the structure for our law. And often in the last administration, much of what was argued successfully was that the executive had gone beyond what Congress authorized. And so that's a fairly conservative kind of argument to make, right? That Congress is the one that gets to set immigration law and that the executive has to enforce that law and implement that law. And so, you know, while there were often also constitutional kinds of claims that were being made as well, the ones that were most successful, especially in the more conservative courts, tended to be claims that were based in the statute. You know, sometimes there are federalism kinds of arguments that can be made, and if you have a certain kind of a judge who may be inclined to try and constrain the power of the federal government, that can sometimes be a strategic choice. It just depends on the circumstances. I know one of my favorite of Gabriela's cases from when she was at the public defender was arguing. She may want to tell this story, but she had a client who had a theft offense. Do you want to go ahead, Gabriela? I'll let you tell the story.
Well, there are two ways I would answer the question, but the story that Maureen is talking about is a client that Maureen gave to me. We were working together well before she had the good grace to hire me. So I thank you for that, Maureen, by the way. Still really enjoying my work here. But this case basically was a client who had come up, he was very innovative, and he'd come up with a scheme to make some money, which involved telling people in his community he was an immigrant himself, that he could get them a driver's license if they paid him a certain amount of money per person, and then he put them all in the van, drove them to the MVA, parked the van, told them he'd be right back, did not return, and went off with their money. And he was caught, and he pled guilty to theft. And at that time, a sentence of over a year would make you deportable, and he had gotten a pretty significant sentence. But part of the sentence that he got involved him paying restitution, paying back the money he had stolen from the people in his community. And so I talked to my client before I made this argument in court, and I let him know that I was probably not going to say the nicest things about him, because I thought that the best strategy for getting the judge to reduce his sentence would be to persuade her that if he were deported, he would never pay the money back, and those people would never see a dime. And so the very worst thing she could do would be to allow the federal government to basically pervert a very just sentence by deporting this individual. And what she really should do is reduce it to make sure that this guy didn't get away with it. So I told my client I would be saying some pretty unkind things about him in court and insisting that he needed to pay the money back, which I did agree he should pay the money back, but that ended up being persuasive to the judge. So sometimes, he had a sad life story, but that would not have won the day in this case. And I think a lot of the times with some of the more conservative judges that I've been in front of, I've said to them, look, you issued a just sentence, but because of the way that the federal government operates, they're taking that sentence and they're perverting it and they're ruining it. And so this way we can preserve the heart of the justice, the heart of your intent, by kind of crafting a slightly different punishment that will keep this person here so that they have to suffer the consequences of their actions, and also so we can carry out the sentence that you, Judge, were so brilliant and just in creating. So everyone likes hearing they're brilliant and just, right?
You know, I certainly do. You can tell me that every day, Gabriela, when we're back at work.
Deserve it.
So Dr. Chacón, I want to bring this back to you for a moment. Having heard all of this, having heard all of these kind of big plans for the center and the work that the center can be doing, are there words that you would give us that you think should be guiding our work, or thoughts that you have about the way that that Professor Sweeney and Professor Kahrl have really laid out what they think our work is?
Well, to be totally frank, I mean, I was a little threatened to be in a room, electronic as it is, full of lawyers. And I'm a scientist by training, so this is a bit of Greek to me. But I realized the importance of what the center is doing and will be doing, perhaps at a higher scale. And I get that. But I think a lot of the emphasis that Deb and I have placed in creating our foundation is the ability of such a venue to affect, to promote education, number one, and the idea of mentoring and seeing young people like Lucy Martin that spoke before, and other individuals that Deb and I had the pleasure of meeting in a previous meeting. It really fills us with great joy that we can affect the future of these young people that will turn into lawyers and judges in the future, and certainly affect in a good way with affecting new legislation, make sort of the political folks, be thinking about these very important issues to the immigrant community. I can't opine on the judgments made by your legal minds, but I do wholeheartedly trust that the intentions, that the strategy is sound, and it is driven by humanity and by sort of a passion for doing the right thing. So, and that's, I guess, do more of that. And I am trying to keep up with the discussion, but I sense in all of the participants, this passion and this degree of care and caring, I should say, that can only, sort of augur, wonderful things in the future. So, Deb and I are delighted to be part of the project. Perched from from a different kind of part of a wall, watching in from outside, but delighted to see it happening. I failed to mention before that why Deb and I, were so much in tune with seeing this project through, and half of the reason why, because of the injustices that we became aware of, but the other one is, and my accent kind of tells the story. I am an immigrant from Central America, and I'm very proud of that, and I think that I was very fortunate to have had the opportunity to express myself in various ways with the help of many people, teachers, professors, employers, and never forgetting where I come from. I want to, or both Deb and I want to try to help those that perhaps have not been as fortunate as I was. So I guess that's a good part of the reason why we acted on this.
And I think that's probably the most lovely and best last word that we could have for this particular conversation. And so I think what we will do is go ahead and close now with first our absolute huge and heartfelt thanks to Dr. Chacón and his wife Debbie Chacón for their support of this center, to Professor Sweeney and to Professor Kahrl for their amazing work for so many years on behalf of undocumented people in our community, to Lucy Martin, who is going to take that tradition forward, and to all of you for being willing to spend an hour of your day thinking about these issues and joining us. We're a couple of minutes early, but I've never heard anyone complain about that. So I will go ahead and sign off, but thank you all so much for being here, and we look forward to seeing you at our next event.
Thank you.